A lot of people have emailed me and asked me about the Genetic Non-Discrimination Act and are wondering, is this a silver bullet that would prevent employers from forcing employees to submit to PCR tests? Today on Don't Talk TV, I'm going to take a look at that. Hello, my name is Nicholas Wansbutter. I'm a criminal defense lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. Now, just briefly, as a bit of a preamble here, I always identify myself as a criminal defense lawyer. Hopefully soon I will be a lawyer insured to practice in all areas. Just today I filed my paperwork with LawPro, the professional liability insurance company that all lawyers in Ontario use, asking them to change my status and increase my premiums so that I can practice all areas of law, not just criminal law. Because I've been working very hard studying other areas of the law so that I can assist people as much as possible in these very uncertain times. So that said, let's take a look at the PCR test. This is still a criminal thing. This is still potentially a criminal matter. I say potential in that there's potential criminal charges to be had. So a lot of people have probably read about that. I want to take a look at the actual act itself and look at a recent Supreme Court of Canada decision upholding that act. Very interestingly, in the Supreme Court case, the Attorney General of Canada was saying, no, we were wrong. We didn't have the ability to pass this. It's unconstitutional. And despite the unanimity of all counsel arguing the case before the Supreme Court, saying, no, the government doesn't have the power to pass this, the Supreme Court said, no, we disagree. The federal government does have the right to put this into law. So that's an interesting thing. Kind of makes you wonder if they saw what was coming. I'm not sure. And frankly, I'll say at the outset, I'm not sure that the Genetic Non-Discrimination Act is necessarily a silver bullet, for reasons I'll describe as we go through this. So let's just take it a step at a time, though, and let's start with looking at the act itself. Genetic Non-Discrimination Act, a 2017 act, and it's an act to prohibit and prevent genetic discrimination. So, always in law, the devil is in the details, and the definitions are very important. So what's the definition under this act of a genetic test? A genetic test means a test that analyzes DNA, RNA, or chromosomes for purposes such as the prediction of disease, or vertical transmission risks, or monitoring, diagnosis, or prognosis. So a couple very interesting and important things here. It doesn't specify only a test of human beings. It just specifies testing of DNA or RNA. And it has right in here diagnosis as being one of the reasons that you cannot test DNA. So then what does it say under prohibitions here? It is prohibited for any person to require an individual to undergo a genetic test as a condition of providing goods or services to that individual, entering into or continuing a contract or agreement with that individual, offering or continuing specific terms or conditions in a contract or agreement with that individual. And it is prohibited for any person to refuse to engage in an activity described in any of paragraphs 1A to C in respect of an individual on the grounds that the individual has refused to undergo a genetic test. So at face value, just by the plain English wording of this act, it prevents stores, entertainment venues, employers from requiring people to have a genetic test before they can enter into a contract with them or partake of their services. So people raise this in relation to PCR tests. Are PCR tests genetic tests? Number of sites you can Google search what is a PCR test, but I thought the Mayo Clinic is a fairly reputable mainstream source, so their definition would be accepted by the courts, one would expect. So they say here PCR test, also called a molecular test. This COVID-19 test detects genetic material. Let me highlight it again here. Genetic material of the virus using a lab technique called polymerase chain reaction. A fluid sample is collected by inserting a long nasal swab into your nostril and taking fluid from the back of your nose, or by using a shorter nasal swab to get a sample. Other sites define specifically genetic material means DNA and RNA. I think most people know that genetic material is DNA and RNA, and that's why it's right in the name of the act. It's not the anti-DNA testing, or the DNA testing anti-discriminatory act. It's the Genetic Anti-Discrimination Act. So we're talking genetic material. So again, it would seem like there may be some possibility here. So let's take a look at the Supreme Court case that came out. It's fairly recent. July 10th, 2020 is when the Supreme Court issued this judgment. So this is, the citation of this case is Reference Re Genetic Non-Discrimination Act, 2020 SCC 17. So I've highlighted a few important things from the majority decision. This was a 5-4 split decision, so I'm reading from the decision of the 5, the majority. So this had been appealed. The Quebec Court of Appeal had said that this was unconstitutional, so the Supreme Court said that they are allowing the appeal of the Quebec Court of Appeal decision and concluded that Parliament had the power to enact this act. So here is important. They're talking about the substance of this act. It says, as I explained below, the matter or pith and substance of the challenged provisions is to protect individuals' control over their detailed personal information disclosed by genetic tests in the broad areas of contracting and the provision of goods and services in order to address Canadians' fears that their genetic test results will be used against them and to prevent discrimination based on that information. This matter is properly classified within Parliament's Section 91, Sub 27, Power over Criminal Law. The provisions are supported by a criminal law purpose because they respond to a threat of harm to several overlapping public interests traditionally protected by the criminal law. The prohibitions in the Act protect autonomy, privacy, equality, and public health, and therefore represent a valid exercise of Parliament's criminal law power. Now, I mean, first of all, reading that, I feel like I'm reading something from an alternate universe when you compare to what's going on with the government right now. I mean, this is the Canada I grew up in. This is the Canada we'd been living in up until March of 2020. This is the Canada where autonomy, privacy, equality, and public health were all key considerations, things to be jealously guarded. Now, I will go back, though. One thing that causes me a bit of pause, and this is where I think the problem is going to be in trying to use this section, is that even though it doesn't say it in the Act, I think it could be used to say it's just the people's genetic tests, because the Supreme Court here says their genetic test results. Does that mean that it means only if you're testing the person's DNA to see if they have some genetic or hereditary predisposition to disease? It's unclear, but on the other hand, there's that specific mention of diagnosis. So diagnosis would seem to be the detection of disease in someone's body, not necessarily their DNA. In trying to determine how successful one might be in trying to argue that a PCR test is a DNA test, I looked a bit further, starting at paragraph 36, where they're looking at the Act's text and structure, the prohibitions created, and looking again at that purpose and what this Act is trying to achieve. So they just review that the prohibitions created by sections 3 to 5 apply to a wide range of circumstances, reiterating obtaining goods and services, entering into contracts in which individuals might be treated adversely based on their decision whether to undergo genetic testing and based on test results. So it says that they target specific behavior related to genetic testing, namely forcing individuals to undergo testing and disclose test results and using test results without consent. The prohibitions target conduct that enables genetic discrimination. So this seems to be talking about exactly what's going on with PCR testing, where people are being forced to take this test, forced to disclose the results, and then they have consequences. Obviously, they're excluded from work. Now, again, I'm sure the argument from the other side is going to be that that's not the sort of thing that's contemplated by this act, because we don't care about their genetics. We care about the fact that they're going to kill everyone because they've tested positive for COVID-19. They're an asymptomatic spreader. As we go through this, I'm kind of expressing some of my doubts about whether a judge would find that an employer has run afoul of this act if a private prosecution were launched. But we'll get into that a bit more later. Let's just read a little bit more. So I think this is important. The Supreme Court reaffirms how broad the genetic test definition is. Paragraph 37, the definition of genetic test in Section 2 of the Act is broad and captures analysis of DNA, RNA, or chromosomes performed with a wide range of ends in mind. So here we go. Since a genetic test is defined as an analysis of genetic material, and again, the Mayo Clinic definition of PCR test is it's analyzing genetic material, It says, I think it is fair to say that the definition speaks to a health-related genetic test, which again, I think that could be a PCR test. It's a health-related genetic test. Indeed, Parliament's particular concern for protecting individuals' control over the results of health-related genetic tests pervades the debates, as I explained below. Health-related genetic tests reveal highly personal information, details that individuals might not wish to know or share, and that could be used against them. This reasoning, again, I feel like I'm in another dimension reading this, because I mean, this is the Supreme Court that we need. This is the type of decision we need to hear, annihilating vaccine passports. You know, they say Parliament saw genetic test results relating to health as particularly vulnerable to abuse and discrimination. And I mean, that's exactly what I've been saying about vaccine passports. I mean, that's absolutely vulnerable to abuse and discrimination. And as we're seeing, I mean, with people, whole swaths of our society being in danger of losing their jobs, people going to be losing their mobility rights that are guaranteed under Section 6 of the Charter. But I digress. Looking at some of the debates in the Senate, see here, some of this is stuff that might be used by the other side, arguing that a PCR test doesn't run afoul of this. So in the Senate, they're saying that if one has genetic testing and discovers that one carries a gene associated with a particular condition or disease, there is no law at either federal or provincial level that provides protection. So again, they're talking about a gene within your body versus finding genetic material from a disease. It's a fine point, but I mean, fine points are what these legal decisions are often these legal cases are often decided on. But I mean, here, look, we're going back to the autonomy, and this comes back to the vaccine stuff. The decision whether or not to take a genetic test is a deeply personal one. There are many factors that a person weighs in making the decision. I mean, again, here, paragraph 47, the court reiterates again that this act is not just targeting genetic discrimination directly through human rights and labor legislation, but also targeting precursors to such discrimination, namely forced genetic testing and disclosure of the results of such testing. And the court found that I find that the purpose of the challenge provisions is to combat genetic discrimination and the fear of genetic discrimination based on the results of genetic tests by prohibiting conduct that makes individuals vulnerable to genetic discrimination. Again, is it the silver bullet? I'm not sure, because I think the counter-argument will be that it's not genetic discrimination. They're not discriminating against your genes or your hereditary dispositions. They're discriminating against the disease that is going to kill other people if you're allowed to be out in polite society. So I think another practical consideration is, okay, this law is out there. It's a crime to force people to take genetic tests. How do you make that happen? I frankly highly doubt that police would be willing to investigate this. It'll probably have to be a private prosecution, and do a search, have a look for my episode on private prosecutions to get a bit more information on that. At this point, I'm not prepared to make a definitive statement one way or the other. The first time I read through the act, I thought, no, this isn't going to fly. We're not going to be able to do anything with this. But I had another look, had a look at the Supreme Court decision. I mean, in some ways, you're going to live by the sword, die by the sword. They wrote a vague law, so they're stuck with fairly vague wording. And courts will generally interpret these things broadly so as to protect the most rights possible. So there may be a shot with bringing these sorts of things. It's going to take someone retaining counsel and being able to fund a significant prosecution. Now, the Public Prosecution Service of Canada will no doubt intervene and take over a prosecution once an indictment or an information is sworn by a justice of the peace or a judge. But even just getting there, I think most justices of the peace or judges would be disinclined to issue this. Their first reaction would probably be, well, PCR test is not a genetic test. So I think you'd need to front load everything to make it impossible for them to say no to you. Bring some argument on statutory interpretation. Bring the Supreme Court case. Bring an expert who can confirm to them what exactly a PCR test is, because you can't rely on like a printout from... You can't rely on what I've relied on here. I mean, I've used it of convenience, a thing from the Mayo Clinic, because it's something widely recognized in society generally. In a court of law, I think you'd need an expert to come and say, look, this is what a PCR test is. This is genetic testing from a scientific perspective. And then force their hand to lay the information. It's something interesting to look into. This video, of course, is not legal advice. I'm just doing this as information. If you want legal advice, you need to retain a lawyer. So you can call another lawyer or myself. My 1-855 number and my website are listed below to set up a retainer and a consultation if you want legal advice. I'm always interested to take suggestions of shows, topics you'd like to see me cover. I can't always get to all of them, but please keep the suggestions coming. You can send them to the email address listed below or leave it in the comments section. And if you found this video at all helpful, informative, or interesting, please consider liking, sharing, and subscribing, and following me on social media.